Welcome everybody this evening to UCL's Faculty of Laws. It's an absolute pleasure to do the honours of introducing a very illustrious panel to talk about a very interesting judgment about climate change this evening. I will say something just very briefly before I introduce the panel, which is I am currently spending all my time being the Dean of the Faculty, but I am an environmental lawyer. And I've always said that obviously I find environmental very interesting. It's a very interesting area of, a very interesting topic, but everyone at heart who is a lawyer is an environmental lawyer. And I think an event like this displays that, the excitement that a judgment like this brings to a wide range of legal thinking, and is an interdisciplinary subject, an interdisciplinary field of knowledge, which is why it's fantastic also to have colleagues from other disciplines here thinking about these questions from a range of perspectives builds the best kind of knowledge. So tonight is a really kind of exciting event, but I think a really important event in thinking about environmental law as a discipline as well. So I'm going to introduce the panel, who are all really illustrious, fantastic people, but I'm going to give them brief introductions because we want to get into the content of the session. So first will be Professor George Letsis, who gets lots of credit for bringing us all together tonight. So thank you, George, for doing that. He's a Professor of the Philosophy of Law in the faculty, and he's held that post since 2014. He's also co-director for the UCL Institute for Human Rights, which is hosting the event this evening, and an affiliate member of the philosophy department at UCL. And is currently working on a book on status in law and morality. I wonder if we can weave that into the discussion this evening. Then next, from the Department of Political Science, we have Dr. Verein Fickfak, who is Associate Professor in International Law and International Relations in the School of Public Policy, and is co-director, I guess with George, of the UCL Institute for Human Rights. So I should give you also credit for putting on this event this evening, Veronica. It's a team effort. And Veronica does lots of fantastic research. At the moment is working on a big ERC project on human rights nudge, which looks at how states respond to judgments of the European Court of Human Rights, which is relevant to tonight's proceedings. Then I'm delighted to introduce Sonam Gordon, who is a PhD student at UCL. And she, and I know this because I am one of her supervisors, has been spending a lot of time for many years ahead of the game on the topic of tonight's discussion, looking at the function of adjudication in relation to climate change problems, and is doing a fantastic PhD project on that topic with funding from the London Arts and Humanities Partnership. Then we have Professor Maria Lee, who has been a professor of law in the faculty since 2007, and who spent a very long time establishing and leading the UCL Centre for Law and Environment. Maria works across many areas of environmental law, including climate change, and also works very extensively with civil society and policymakers. And then last but not least is Professor Lisa Van Halle down the end, who is a professor in political science and does lots of amazing work, and has a grant at the moment looking at the politics and governance of climate change, loss and damage, and recently was appointed as the UCL's co-lead of our grand challenge of the climate crisis, as if it needed to be branded as, I think we already knew it was a grand challenge, but UCL is officially nominated as a grand challenge. So this is the esteemed panel. They will all speak for a number of minutes that I will keep an eye on the clock to make sure they stick to their minutes, and then we'll have time for discussion. And Lisa, you're going to lead the discussion, which is fantastic. I will now hand over to George.
Thank you, Eloise. Thank you all for coming. Welcome to our event. I want to talk about the case, and what I'll do is briefly summarize the case and introduce it for those of you who may have not had the time to read the judgment. It's a long one. You may have seen reports of it or summaries of it. So what I'll do is talk about the case, introduce it, summarize it in my own way, and then finish with some critical comments about it. Now, 3 weeks ago, the Grand Chamber of the European Court delivered 3 judgments on climate change, and it was the first time that the court addressed climate change as a standalone issue under the convention. The most important of these 3 cases is the case of Verein KlimaSeniorinnen KlimaSeniorinnen Schweiz versus Switzerland, in which the court, the European Court of Human Rights, for the first time found a breach of Switzerland's obligation under the European Convention with respect to climate change. Now, the case, if you have been following, was brought by two sets of applicants. First, an association of women, mostly over the age of 70, as well as individual applicants, 4 women, who were also members of the association. So you have 2 separate applicants bringing this case. The applicants had earlier unsuccessfully sought to take legal action in domestic courts in Switzerland, requiring the authorities there to reduce the greenhouse gas emission of the state below 2 degrees above the pre-industrial levels. So they had sought action in domestic court, which was rejected by the domestic courts. Now, when the case went to the court, the European Court of Human Rights, after remedies were exhausted, it seems to me, at least, that the court faced an enormous challenge. And this was to do with the specifics of the conventions, the mechanics and the doctrines of the court. And I started to explain why a case like climate change posed this challenge to the court. The main issue, just very briefly, is that it's not obvious at all within the context of the convention how the climate change issue falls within the scope of the convention, nor was it clear the extent to which the court can require states to take specific measures to reduce greenhouse gas emissions. So 2 general issues here is whether the case falls within the scope of the convention and the extent to which the court can order a state to take specific measures. These are roughly the challenges, but to see exactly why they were challenges, I want to highlight 4 issues in specific. First of all, for an application to be admissible before the European Court, the applicant must show that they have been affected in the exercise of a convention right. In the text of the convention, however, unlike other instruments, there is no explicit mention of a right to a clean and healthy environment. So environmental issues before the court previously had arisen indirectly only when and because they have affected one of the rights of the convention. This was typically 2 rights: the right to life under Article 2 and the right to respect for one's private and family life and the right to a home under Article 8. So the adjudication of environmental issues before the court has to be indirect through affecting the exercise of one of the rights of the convention. Second, for the application to be admissible, the applicant must show victim status, which means that they must show that they have been directly affected in their exercise of the convention right. Not only that there is a convention right that's been affected, but they themselves have been directly affected. Now here, what this means, based on previous case law about environmental harm, is that the applicant must show that they have suffered a minimum threshold of severity, must have been above a minimum threshold of severity in the harm or risk of harm, but also that there's sufficient close connection between the harm or risk of harm and their exercise of the right. Now, this, on the court's reasoning, follows from the fact that the convention prohibits the so-called actio popularis. It's a Latin term that I'm sure most of you are familiar with, which is an action brought by individuals not exercising their own rights, but in the public interest. So actio popularis means an action any individual can bring, serving the public interest, not trying to vindicate their own rights. I should note here a crucial detail that actio popularis does not prohibit a large number of applications being brought if numbers of individuals can show that they have been victims under the convention. So conceivably, thousands of people, even I suspect millions, could bring a class action, a group action, and join it together if they have victim status. That's not actio popularis. Now, the court itself defines the prohibition against actio popularis as follows. An applicant cannot lodge a claim in the public interest if the impugned measure does not affect him or her directly. Note the emphasis so directly here. Now, third issue that poses a hurdle for climate change or posed before the judgment is that the applicant must show that the environmental harm or risk of harm can be attributed to acts or omissions of the respondent state. In the court's previous case law, environmental harm was always localized. It had to do with things like floods or toxic waste or emissions that affected a particular section of a population in a particular region, and the state was causally responsible, either through acts or omissions, for that harm. By contrast, climate change poses a risk which is global rather than localized, and it comes from aggregate emissions rather than the emissions of a single state. Even if one state, like Switzerland, did all it could to reduce its emissions, this measure on its own would not suffice to reduce the risk of harm that individuals within Switzerland face unless all other states also take appropriate measures. This argument is known as the drop in the ocean argument that many other courts, domestic courts, have already previously rejected in the context of climate litigation. Now, final hurdle that the court was facing before the judgment is the so-called margin of appreciation. This doctrine, which falls under the principle of subsidiarity, means that when the issue concerns the positive obligation of a state, the obligation of a state to take measures, the margin of appreciation shown to it by the court is very wide. The margin is also wide when the issue concerns complex matters of policy, as to which there may be more than one way to pursue compliance with the convention obligations. The 8 countries that intervened in this case, all members of the ECHR, stressed the argument that, on their view, the margin of appreciation given to states for climate change must be very wide. Now, how did the court overcome these obstacles? Now, first, let me talk about victim requirements. The court reaffirmed the prohibition against actio popularis. And it reaffirmed that the convention does not normally allow a person to bring a complaint without being directly affected. Nevertheless, the court thought it is possible to square the prohibition on actio popularis with examining risk of harm linked to climate change. So that's the crucial attempt of the court, to square these two things. Can you square actio popularis with addressing climate change harm? The way the court approached this is in terms of a dilemma. If you keep standing very narrow, then you don't allow the examination of any harm attributed to climate change. If, on the other hand, you make standing very wide, then you open the floodgates of litigation, and any individual can bring a claim, and then this raises issues to do with separation of powers under the constitutional setting of every member state. So too small standing, too narrow, no vindication of rights; too wide, actio popularis. So what the court did is to devise a new test for standing, which steers a middle position. That was the thought. The middle position is this: with respect to individuals, the court says there's a very high threshold. So if you're an individual, you have to show two things. First, a high intensity of exposure to the adverse effects of climate change. And second, a pressing need for the government to ensure individual protection, that is, protection of individual people or persons specifically, not everyone. So very high threshold for individuals. But with respect to association, the threshold is actually lower. This is what the court innovated. The court said that an association can bring an action not in its own name, not asserting its own rights, but on behalf of its members. Crucially, however, and here's the innovation, it is not a requirement that the association assert a violation of their own rights, nor is the requirement that individuals on behalf of whom the association brings a complaint must, qua individuals, qualify as victims. So the members of the association that brought the case don't have to qualify as victim status for the purposes of the case. And indeed, this is exactly what the court found, applying the new test. The application of the 4 women was deemed inadmissible. The court did not find that the 4 women meet the high threshold for individuals. that is high intensity of exposure and pressing need to ensure protection. By contrast, the court found that the association does meet the criteria. The criteria, I think, are fairly easy to meet. So the association must be lawfully established in the country under which the jurisdiction of the respondent state falls, and must genuinely represent the interest of its members. The court was less worried about issues of causation. It repeated that causation doesn't have to be but for causation. Even if Switzerland could not on its own prevent global warming, or the warming in Switzerland, it is still partially causing global warming by not doing its fair share under the principle of common but differentiated responsibilities to combat climate change. Now, this is how the court overcame the hurdle of sorry, how I'm doing that with time, Louise. Yes. So this is how the court addressed the issue of standing. With the issue of merits, the court found that the marginal appreciation, so once the admissibility issue was resolved, the court found that the marginal appreciation attached to states to combat climate change is reduced. More specifically, it held that effective respect of Article 8 imposes a positive obligation on states to take measures for the substantial reduction of emissions with a view to reaching net neutrality within the next 30 years. For this to be feasible, the court stressed that there must be a regulatory framework at national level, followed by adequate implementation. States have to set targets for intermediate gas emission reductions, show evidence that they're doing this in a way that it's adequate and likely to meet those targets. Careful here, the court stressed that all these intermediate targets and evidence that each state has to show that they are meeting is an overall assessment. A state can be doing badly in one respect, but better in another. It has to be a case-by-case examination of the context of each state. Now, this brings me to ask, of course, in this case, the court found that Switzerland had failed to have adequate framework because of gaps in the legislation of Switzerland to set targets for the coming years between 2025 and 2030. This, again, issue to note, may have to do with specificities of Switzerland, including the fact that proposed legislation to set targets had been rejected in a referendum in Switzerland. So the gap there related to specificities within Switzerland. Now, moving on to sort of some set of criticisms and critical comments, we need to ask whether this innovation of the court, the new test for standing, and the reduced marginal appreciation is activism, maybe justified activism on the part of the court, or is the court acting within existing legal principles? The judge who issued the separate opinion, who dissented, Justice Tim Mike, thought that this was going beyond existing case law. He argued that the court did exactly what it said is not allowed by the convention, namely to create a basis for actio popularis. Now, it seems that the judge has something right, that the court itself, when it analyzed the reasoning, presented the new test as a pragmatic compromise, as opposed to an issue of principle. However, I want to propose here a different reading of the judgment that defends how it is compatible with previous case law, and that this is not a case of activism. This alternative reading that I'm going to propose has basis on the court's reasoning. And I want to highlight here the references of the court to future generations, which I think is key. The court throughout the judgment placed emphasis on 2 points. Future generations are likely to bear increasingly severe burden of consequences of present failures to combat climate change. And second, future generations, and for me this is the most crucial part, have no possibility of participating in the relevant decision-making processes. They are not represented in the political process. So we are harming future generations by inaction, but these people cannot complain because they're not represented in any decision-making. Now, this lack of representation, for me, was crucial both to reduce the margin of appreciation and to revise and modify the test of standing. The court referenced future generations in the course of developing the new test of standing. Now, why is that compatible with the previous case law? You can see the standing afforded to associations not as a public interest litigation mechanism, that associations are pursuing public interests when the members are not victim status, but you can see association as representing the rights of future generations. Now, this is not foreign to the convention. The idea of a future violation is there. So the court has already accepted that a violation may occur in the future. So in cases of extradition, like the landmark Verein judgment, a violation will occur at a later stage, but someone already has standing to complain. Also, the court has accepted that associations can bring a claim on behalf of a victim who is unable to bring it. Again, future generations are unable to bring a case against current inaction and failures by the government to combat climate change. So I think it's the new standing test is better seen as a way to vindicate the rights of future generations, which otherwise wouldn't be vindicated. If you say that, you reject the idea of active popularis. You don't see the standing of associations as merely in the public interest. Likewise, you can accept that current people, their situation hasn't reached the level of severity to qualify as victims. And the way this is compatible with the convention is that we know with certainty that unless we take action, like states take action, future generations will be victims with great certainty. And we also know that they're unable to bring an action. So I think this reading, which I think, again, to repeat, finds basis in the court's case law, can answer the worry people have that this is going beyond existing case law. Now, finally, one might object here that the rights of future generations are not really possible to be litigated under the convention for two reasons. The harm is too remote in time, and second, these people don't exist. Now, I think the court already has accepted that neither of those is an issue. You can imagine states implanting a mechanism in an individual which is going to explode in 70 years and cannot be removed. Surely this case will be qualified as standing under victim status under the convention. The fact that the harm will come about in 70 years wouldn't be a problem. Likewise, the court has accepted and ruled a violation for rights of people who don't exist because they have died. They're no longer in life. So I don't think that the rights of future generation is an obstacle under the current principles of the convention. Nor, of course, is it the case that just because a threat to the conventional rights is new, that the right is new as well. The right is old, the threat is new. Thank you very much.
Super, thank you so much. So a lot of people have described this judgment as groundbreaking, and George asked whether or not it was an active judgment, and I'm going to join him in actually labeling it as a very modest judgment. And I'll be focusing on speaking about remedies. But before I do so, I thought I'd make a preamble for us to think about the context in which this decision was actually rendered. And I know Maria and Lisa will talk about this a bit more, but I think it's really important to keep in mind that this decision and these judgments came at a time of increasing climate change litigation, where a number of international courts and domestic courts are dealing with these issues. And this has, to a certain extent, created not only competition between courts, who's going to be the first court to decide it, who's going to be the most active and progressive, but it's also created pressures on the court, pressures on the judges. And so European Court of Human Rights judges would have seen the crowds gathered in front of the court. They will have heard about Greta visiting. They would have seen about the number of people coming to the hearing and coming to hear to the judgment. And that does not affect you. So that's sort of one part of the story, to think about this judgment actually in the context in which it was rendered. The other thing I think we need to keep in mind before we go and look at the legal moves that are in the judgment is that to a certain extent, so the primary audience of the court are the member states. They're the Council of Europe member states. And it is to these countries that really these judgments are written. And the UK, for example, appeared in front of the court saying that the court really shouldn't be making a decision here and acting as a legislature, that it should be allowing states themselves to decide these questions. And what the court does in the judgment very clearly says, we as a court have a role in this context. This is not only an area where the will of the people, the will of the majority should be heard, but the court as a protector of minority has an institutional role. And so I'd like us to think about both standing and the remedies points I'll make in that context. So I hope this works and that this mic works. So it is in the context really of thinking about the mobilization that is happening versus the member states that the court is talking about, that I think we need to think about the decision, and I think we should think about the decision as an actually very modest decision. So I will focus on the issue of remedies, and I'll do it from two perspectives. One is the exhaustion of domestic remedies, and then the remedies, the measures that a state should be taking. And really, in terms of the first one, in international human rights law, the basic condition for bringing a claim to an international court is that you need, as an applicant, as a victim, you needed to have exhausted domestic remedies before you turn to an international court, to a human rights court. And that is what the court rules in the Portuguese case, in the Duarte Agostinho case, right? It says that this case is no different from other cases, and that under normal international law, under normal human rights law, applicants need to give domestic authorities, domestic courts, the opportunity to redress the problem before they turn to an international court. And what the court is saying is that this situation is no different, and that we have a number of examples like Uganda, but also other litigation around Europe and around the world, really, where domestic courts have ruled in favor and where they have provided a forum where these cases can be litigated. And it is only when domestic courts fail, like they did in the Swiss case, in the KlimaSeniorinnen case, right, where the court says the Swiss courts did not take the claims of the applicants sufficiently seriously. They did not even engage with the actions at all. It is only then that an international court comes in. So the court is very much deferring to the domestic authorities, but it's also telling member states, we need to solve this, giving them an opportunity to solve this at home. So it's very much underlining the subsidiary role of human rights protection of itself as an institution or as a human rights protector, if you like. The other point goes to the remedies as measures that need to be taken in response to a violation. And so, as George said, and really beautifully mapped out, there was a finding of a violation of Article 8 in the KlimaSeniorinnen case. And there, the question really arose is what the court was going to say that the state, Switzerland, needs to do in response. And if I can just slightly nuance what George said, the court says that the state has a reduced margin of appreciation when it comes to the necessity to act. So the state has to act to combat climate change. It has to mitigate and reduce greenhouse gas emissions, but it doesn't tell the state how to do it. And in relation to the how, there's a really wide margin of appreciation, and the court will take into account this holistic picture of the measures that have been taken, the targets that will be set, whether or not those targets are in line with the scientific evidence, whether the state has worked, it has taken action in good time, et cetera, et cetera. So it will look at all of that. And that approach of bifurcating, if you'd like, the approach to the margin of appreciation, saying you have to act, but how you do it is up to you, the state. So you have to have a plan, but how you do it is your call. That is entirely consistent with existing ECHR case law. Actually, on the project that I run, we've looked at 26,000 judgments of the European Court, and in 99.9% of cases, so we've got only 328 cases, in which the court actually goes ahead and says, this is what the state needs to do. So this one falls in the 99.9% majority.
So as a rule, what the court will always do is give leeway to states to voluntarily propose how they wish to meet their own legal obligations. But the court also does one more thing, which I think is sort of not being mentioned sufficiently. In the judgment, it says, this is not for us to decide. This is for the Committee of Ministers to decide. This is a specific and separate legal, political body of ministers and representatives from different Council of Europe states who meet together and decide how judgments should be enforced, how the obligations coming from the Klima case should be met. And that's what they will do. And I think the really interesting story from this judgment starts now. Not in April, but it starts now, because now the discussions are beginning about what we should expect in terms of measures from Switzerland and from other countries. And I was actually in town in Strasbourg at the time that this judgment was rendered, and I was at the Department of Executions, which is the staff or secretariat that works together with the Committee of Ministers on thinking through remedies and measures and good practices on how to meet obligations coming out of these judgments. And what the department is currently doing is really soliciting input, soliciting feedback, and really asking NGOs and civil society to come through and provide information about what measures, what remedies, about the how. How should this decision be enforced? How should this be met? So that they can feed that into the political discussions of the Committee of Ministers. So even though the judgment is modest in terms of what it says, I think the really interesting thing is going to happen from now on. And, I definitely encourage NGOs and civil society to think about using procedures like Rule 9 to intervene in the process at the political level and feed in their thoughts about the necessary remedies in this process. So I'm going to stop there and really conclude by saying, yes, this is the first time that the European Court of Human Rights has ruled on climate change. But it has done so within the confines of ECHR jurisprudence. And the really interesting story begins, I think, from now on.
So my focus today is on the role of courts and what the Klima decision really tells us about how we understand the role of courts in responding to climate change. We've already talked about the fact that allegations of judicial activism reared their head as soon as the decision was handed down. And what is particularly interesting about Klima is this controversy is within the judgment itself. So the starting point of my contribution is the dissenting opinion of Judge Tim Ike. As he put it, the majority are giving false, in bracket, hope that litigation and the courts can provide the answer. He conducts a critical evaluation of the majority's reasoning, particularly on Article 8, and considers it tantamount to the creation of a new right. And he concludes that the majority went beyond what was legitimate for the Strasbourg Court and clearly tried to run before it could walk. His dissent is not about this particular case. In his own words, it is of a more fundamental nature that goes to the very heart of the role of the court in the context of the unique and unprecedented challenges posed to humanity. But simply, Judge Ike is saying that climate change at this current point in time sits firmly outside the jurisdiction of the Strasbourg Court and the European Convention. I think this really matters, not because I think he's correct, but because Judge Ike is not alone in his concerns. There are very real and deep worries about whether climate change problems are amenable to judicial resolution. And when a decision like Klima is handed down, these debates become particularly intense. The majority and the dissent adopted two very different understandings of what the proper role of the court is. And my argument today is that we shouldn't shy away from those debates, but we take them seriously. And we engage with those points of tension and disagreement. And that's because when we do this, we're able to build robust arguments about what the proper role of the court might be and move away from discussions about judicial activism. This might feel unsatisfying. Why am I talking about the dissent? Why am I undermining the victories of the climate cause? Because I want to emphasize that doing this work for courts, adjudicating climate change, is really hard work. The length of the judgment is testament to the fact that this decision required some soul searching. It was not a straightforward case. It required a very detailed examination of the relevant legal issues, the arguments of the parties, the factual and scientific complexity of climate change, as well as, of course, the scope of the convention. In other words, the Strasbourg Court had to decide what its job was, it had to do its job, and it had to do its job well. So I'm going to focus on 3 ways that the majority and the dissent disagreed about the proper role of the court. And showing these divergences doesn't provide any perfect answers, but what it can do is move away from debating about courts at an external level and rather engage with their internal process of reasoning. Now, the first point of divergence is in how the 2 opinions understood their constitutional competence. What did it mean for the court to act within the bounds of its legitimate authority in a democratic society? While both the majority and the dissent acknowledged the limits of its competence, they took diverging views on what those limits looked like. So with the majority, they explicitly understood their role to be complementary to democratic decision-making. In their preliminary remarks, they reflected on the broad question of the role of the court, explaining that democracy cannot be reduced to the will of the majority of the electorate in disregard for the requirements of the rule of law. They remind us that the task of the judiciary is to ensure the necessary oversight of compliance with legal requirements, and that the remit of the court is complementary to those democratic processes. In contrast, the dissent emphasized that the role of the court was to carefully weigh up competing rights and interests, and to do so in a way that takes a subsidiary role to the democratically elected legislature. I would argue that complementary and subsidiary are 2 quite different conceptions of the role of the court, the rule of law, and its contribution to a healthy and functioning democracy. Second divergence is in how each opinion conceived of the institutional expertise of the court. Climate change is a highly complex scientific, social, and economic problem. The argument often goes that courts don't have the requisite expertise to handle disputes of this complexity. The majority's approach was to accept that the case involved compelling present-day conditions confirmed by scientific knowledge, which the court could not ignore in its role as a judicial body tasked with the enforcement of human rights. Judge Ike, on the other hand, queried whether and how the Strasbourg Court could adequately contribute to the issue, reiterating that this difficult social and technical sphere is not currently part of the court's working practices. Again, 2 very different understandings, the latter lending itself very easily to Longfuller's orthodoxy about the fact that polycentric disputes sit outside the realms of adjudication, with the former embracing the question of expertise of the court. What is it that the court is good at doing, and how might it do it in the context of this problem? Which leads to the third and final point of divergence, which is how each opinion understood the nature of their interpretative role in light of a problem like climate change. Both decisions were, of course, grounded in established jurisprudence of the ECHR. Both decisions also acknowledged the urgency and importance of climate change, but again, very big differences in what this meant for the process of interpretation. The majority saw this as a matter of adapting to the issue before it, whereas Judge Ike saw the applicant's argument as akin to the creation of a bespoke new right under the convention. So the majority took their interpretive role head on. What is particularly striking to me is the explicit recognition of the complexities facing courts when adjudicating climate change. They note its diffuse causes and consequences, its cumulative nature, its polycentricity, among everything else. And it didn't shy away from those characteristics, but actually engaged with them, and noted at paragraph 422 that because of these fundamental differences with other environmental problems, direct transposition of that case law of the ECHR would be inadequate and inappropriate. They considered it necessary to take an approach that acknowledged and took into account the particularities of climate change, but while also drawing inspiration from the principles set out in the court's existing case law. So a process of reconciliation. For Judge Ike, this was off the table. He emphasized that the court's interpretive authority came with immense responsibility. He said it demanded a careful, cautious, and gradual approach to the evolutive interpretation of the convention, and he saw the majority's reasoning not as a tailoring of existing principles, but rather as the creation of a new and bespoke right under Article 8 altogether. which for him, of course, went beyond the scope of the convention and beyond the competence of the court. So where does that leave us? Well, what I've tried to show is that each opinion adopted a different understanding of how to reason the case, and that approach was grounded in their understanding or an implicit assertion about what the proper role of the court is. I haven't conveyed a huge amount of new information, and I don't think that these questions are unique to Klima or even to climate change. They come up time and time again when a court is faced with a novel problem. The point of highlighting it here is to enable us to move away from seeing this as a black and white issue. Climate change, yes, climate change, no, judicial activism, victories, but rather towards a reflection on how we might think about the proper role of courts moving forward and how that role might be evolving.
Okay, thank you. I'm going to move on slightly. I'm going to suggest that perhaps climate lawyers pay too much attention to cases, to courts, to climate litigation. I'm going to ask why, and I'm going to suggest why it might matter. It's all very tentative. So first of all, to say that there's too much attention to cases, I recognise that's doing too much work, really. Cases are important and cases do need attention, but I do think they can dominate the discussion. They may sometimes be a distraction or even worse. Cases, I think, broadly speaking, have an outsized presence in academic thinking about law generally, not just in climate. We much prefer to talk about cases over other legal mechanisms. And similarly, in our work on environmental NGOs, Carolyn Abbott and I have observed an instinct. It's not a universal instinct, but it's shared by lawyers and non-lawyers, an instinct to identify law almost entirely with cases. In addition, this idea of climate litigation, a thing, a sub-discipline of legal practice and scholarship, it's new and it's really unusual. We don't do that with anything else yet. Climate litigation as a single phenomenon, I think, is even a bit misleading. The cases are subject to their specific legislative, constitutional, administrative, judicial contexts. But it's a really powerful framing, and I'm not saying that as a bad thing. It's a really powerful framing. It provides a sense of inevitability and rightness, and successful framings like climate litigation are generally very hard won. So it's an interesting issue. So why this focus on cases? It's in part because litigation is indeed a necessary part of the complex legal arrangements to respond to climate change. It is part of it. And all the legal instruments have their limitations, obviously. In addition, courts can enhance the voice of the least powerful. Women in their 70s and 80s are a group that is not much seen and not much valued in our society. Now, unfortunately, they do rather disappear, especially on George's, I think, really excellent interpretation of standing. The older women do disappear from the case. So perhaps this is a fairly ambivalent example in that respect. But in addition, cases can contribute to the way we think about complex problems. So, for example, perhaps the court's inclusion of future generations, global impacts, embedded emissions in its reasoning points us towards questions about responsibility for things and people that are distant in time and space. Cases play lots of other important positive roles, but I don't think climate litigation dominates our thinking just because it's a good way to get things done. There are other reasons. For academics, it allows us to use the skills we most value, the skills of analysis, much more than other legal instruments. For civil society, there's this lovely, clear narrative. Cases have an attractive, sudden eventfulness. It's a thing that happens, and an apparent, illusory conclusiveness. Within the NGO environmental community, cases have a profile and a presence that more routine legal work may not. So a good case can make a career. Giving a bit of advice to campaigners on the emissions trading directive probably won't. And funding really, really matters. Occasionally, litigation will be funded from an NGO's general funds, but a lot of litigation is funded by a few large philanthropic organisations and their intermediaries. Now, foundations are diverse, they are complex, they fund all sorts of interesting activities. But if I am going to generalise, and I am, they prefer to fund a project, something with a beginning, an end, and an outcome. And cases really do fit that bill for them. Is crowdfunding also likely to prefer litigation over other ways of working? What about the way costs allow external lawyers to help with litigation in a way they can't help with other legal activities? These funding mechanisms aren't problematic. I'm not, concerned about them, but it is certainly plausible that the funding of climate law prioritises this particular method of achieving change. If I'm right, and climate litigation has this outsized profile, does it matter? I'm going to make 3 quick suggestions. First 2 are about being distracted, really. So first of all, the case for the climate transition ultimately has to be won politically, not through the courts. That becomes ever truer as the climate transition and so the politics get harder. And we're seeing that right now. To be clear, this is not an argument that courts are undemocratic. Courts are a crucial part of any democratic society. And cases might be part of winning that political argument. My point is that we can't do the climate transition to people. We have to do the climate transition with people. Second, if lawyers are busy litigating, what are they not doing? Law is ultimately limited when the politics gets rough, but we really need legally protected institutions to make progress. Some legal energy goes into new legislation, the Climate Change Act, the EU climate laws. They had a high academic profile and some fairly impactful interventions by civil society, I think. But the constant stream of secondary or less obvious legislation, which dramatically affects our ability to make progress on climate, doesn't get the same sort of attention. And the legal effort involved in the implementation of new legislation and indeed of cases, as Veronica suggested, is increasingly recognised, I think, by NGOs and their funders, but it's less appealing, much less appealing. And I don't just mean checking compliance, has government complied? I mean the day-to-day routine business of implementing law as we govern the world. So, for example, the ECHR in our case, it doesn't quite require, but it nearly requires a binding regulatory framework with targets, with timelines, with carbon budgets or equivalent quantification, with intermediate targets, all updated with due diligence. I don't think that's leaving it to the states to decide how to do things. I think that's telling the state how to do it. But this is going to come back to court. It's going to be dealt with by the council. But really, what that means in the world is in the day-to-day business of governing. What does it mean for actual greenhouse emissions in actual greenhouse gas emissions in actual decisions on stuff we're going to do or not do? Who is going to be in that room? Environmental NGOs can and do contribute to these conversations, but these are ways of working that are hard to fund and hard to value. Third, finally, can cases do harm, even if they're positive decisions, beyond diverting attention? There's lots to say, but briefly, the sorts of climate governance mechanisms that the ECHR proposes, I think they're a very good thing. We use the law to support political accountability through publicity of targets, budgets, plans, progress. But I am still hoping that somebody is going to have a better idea than that. I'm still hoping that there's something else we might do. And I wonder whether applying the universalism of human rights to these very particular arrangements leaves sufficient space for other ways of thinking about this challenge. And similarly, is net zero by 2054-ish, which is what the ECHR suggests, is that really good enough to cascade across the whole Council of Europe? you know, I don't think it's a bad case. I just ask these questions. And no doubt this case and how to take it forward is going to absorb a lot more attention, as it should, because it's really important. But I hope we don't neglect the other things, the less exciting things that we should also be doing.
Lisa.
Yeah, that's great. I feel like my role on these panels a little bit is to be the climate litigation killjoy. And I have to say on this panel, I feel a little bit less lonely. I'm really grateful for this very nuanced set of remarks. I'm going to speak very briefly. I'm thinking very much from a sociological or sociolegal perspective. The literature I work in focuses on legal mobilization. It's a literature that seeks to understand why and how some groups or some individuals might turn to the law to address their grievances, or might even understand their grievance as a legal one in the first place. So it looks a little bit at that kind of front end of litigation. Why are groups able to go to court or not? And what shapes that? And then it also looks at the back end of that. What are the consequences when we use litigation more broadly in society? What are the legal consequences, has been talked about in a lot of kind of beautiful detail, and the finer points of law have been addressed. But what are the consequences in terms of sociological and political changes that might come about because of litigation? So let me say a little bit about these kind of two ends, and I'm really bracketing the legal case itself here. So looking at that front end, these kind of theoretical currents that explain why groups might look at turn to the courts. And Maria, I think, has spoken about a lot of this beautifully. So I'm just going to add a little bit of theoretical scaffolding from my perspective on this. So there might be a number of different reasons that explain why groups are able to go to the court or not. And we tend to focus on those groups that do, and particularly those cases that are successful. And there's a real selection bias in the way that we talk about climate cases in the literature on climate litigation. But we might want to think about the legal stock, what law is available and who has access to that. We might want to think about legal opportunity structures, those facets of the political and legal system that enable or constrain litigation or other forms of mobilization. So here we would think about the procedural rules, standing rules, cost rules, but maybe also, as a political scientist, I would suggest the receptiveness of the judiciary, their ideology, their understanding of the issue, the expertise that they bring to bear on this, and what kinds of knowledge they have of the climate science. We might also think about the way in which groups or individuals are able or not able to mobilize resources in pursuit of litigation. In classic kind of socio-legal theory, Mark Galanter talked about the haves coming out ahead in court, that repeat players, those that are able to go to court over and over and learn how to use that process, are more likely to be successful. What does that say about the kind of society that we live in, if that's the types of cases that are successful? But also increasingly, we think about other types of resources within this literature, the role of strategy entrepreneurs within NGOs, floating the idea of taking a legal case in the very first place, the kind of complementary campaigning capacity. And as Maria, I think, beautifully outlined here, behind this climate litigation movement, there is an alliance of NGOs, funders, academics, who are really pushing this movement in a particular direction, for better or for worse. Charles Epp talks about this as the support structure in his work on a rights revolution, and I think we can increasingly see that in this climate litigation space as well. But some of the other things that might be pushing groups or individuals to the court relate to identity. Some groups might be more likely to see themselves as rights holders and as the court as being more appropriate for the kinds of grievances that they're experiencing or anticipate experiencing in the future. We need to ask, what are those sociological mechanisms that really allow individuals to understand themselves in this way, whereas others might not, and to understand their grievances as ones that can be understood through the lens of the law. And then, of course, I referred to the selection bias. We're here talking about older Swiss women and much less about Portuguese youth or the French mayor who had taken the case. What happens to those who don't win, whose cases aren't even taken forward in the first place? And then, of course, there's a whole other set of thinking about how to assess the impact or outcomes or the consequences of the legal mobilization. And increasingly, we're thinking, particularly with funders of this litigation, of how do we evaluate this? What's the right way of assessing whether we are successful here? The kind of legal judgment is one small part of this ultimately. So I think that leads to kind of two reflections that I suppose I want to kind of finish our session of the panel on before we move to the questions. One is about who gets to have their day in court, right? There is, of course, the law that makes that decision, victim status we've talked about, but there are also the optics here, right? Whose identities are deemed to matter, who is kind of seen as legitimate, who are deemed legitimate rights holders, who are not. I was really struck by the images after the judgment of media speaking to these older women who I agree are often marginalized or rendered more invisible in society. But behind them, you could see the young people kind of peering over their shoulders. What are the consequences of that kind of optics for climate politics more generally when young people are rightfully angry at the lack of action that's been taken? There are intergenerational dynamics here in terms of the sociological and societal effects as well. I think it's also right to really ask the question, and Veronica put this beautifully, of what happens now. Gerald Rosenberg, in his classic text, The Hollow Hope, notes that courts have no influence over either the sword or the purse. Switzerland's system of decision-making via referendums, I think, is consequential here, and it might be worth just revisiting what had happened in some of the politics on this leading up to this decision and alongside this decision. And there will be others here who have a lot more expertise in this than me. But it's worth noting that Switzerland's climate policy kind of continued to face challenges in the last few years. It was rejected. An amended Carbon Dioxide Act was rejected in a public referendum in 2021. This forced Switzerland to extend the targets from its previous Carbon Dioxide Act that would have expired at that point. Of course, in 2023, there was another referendum where the climate protection law, which binds Switzerland to climate neutrality by 2050, did receive support of the Swiss people, but that was after a long political debate where the opposition was framing the Climate and Innovation Act as an electricity sinkhole. So, of course, I think Veronica is absolutely right that this is the beginning of the process. The Committee of Ministers has some work to do, but there is a domestic political context that we need to understand here if we really want to deem this case a success or not. So I think it's worth really thinking about this case in all these different ways that we've done, the kind of finer nuances of the points of law, but also moving away from that internal logic of law itself to understand some of the broader social and political consequences. And I look forward to carrying forward the discussion from that.
I just want to thank the panel. It's an amazing display of UCL talent, but I'm not going to focus on that. But that one case can provoke so much profound thinking, I think says a bit about the case, but a lot about the challenge of climate change and how it's forcing us to think deeply about things that we often take for granted. And so a lot on the table for discussion. At this point, I'm really sorry, I have to excuse myself, but Lisa is going to very capably manage the discussion, and I think go for it. I think everything's on the table.
Yeah, we're good. And Monty was going to help us with a roving mic. And we also, I know, have some comments online, and George was going to help me navigate some of those, but maybe what we do is take 2 or 3 questions from the room. We'll let the panel respond, then we'll go online, and then we'll come back and see what we have time for. So I'm going to start with sorry, your mic is already I supervise Monse, but she's just submitting her first draft to me, so she's feeling powerful. That's good. Yeah, that's great. Go ahead.
I'm already hogging the mic. Is this on?
Yes.
Yeah, great. Thank you. Hello. I've got particularly a question for Professor Fickfak. I thought your point about the implementation and what's going to happen next, particularly important. It kind of ties in with Maria's point of there's always this sort of let's move on to the next interesting case, but this is a case that has to be stuck with, and there's a whole process now at the Committee of Ministers. So I have 2 questions on implementation. The first is, I think if I remember correctly, I think the Committee of Ministers implementation of judgments meetings, I think they're about 3 a year. And of course, there's a choice to be made about which cases are up for discussion on implementation. you couldn't have all cases due to be implemented on that list. So how soon are we likely to see this case coming up for discussion? And my second question is, when it does come up for discussion in Committee of Ministers, what shape do you think those discussions will take? And what do you think, and I'm asking you to look into a crystal ball, is the likely outcome of those discussions? What do you think would concretely be recommended to Switzerland in this case?
I might take another couple of questions and then, yeah, so Annalisa, yeah.
Oh, thank you. Thank you so much. Annalisa Savarese, University of Stirling. I have two questions, if I may. First one is for George. Are we sure that the Swiss applicants were that different from Mrs. Fadeyeva and other applicants that were victims of systemic pollution that affected virtually all citizens of a city? I'm not sure I agree with the quote on that. Second, Maria, I so agree with you. We are maybe focusing too much on litigation, losing sight of enormous glaring gaps in the implementation of the law. Look at Scotland, backpedaling on targets and really not doing what it should be doing. Disclosure, I sit on an environmental law enforcement body in Scotland, and we are asking ourselves, what do we do? Do we sue them? What tools do we have? There are shortcomings in the making of the law that are not being addressed properly. And if this is the case in the UK, the first country in the world to adopt legislation, we are in a bad place.
I'll take one more from the back in the blue shirt. Yeah.
Hello, thank you very much for the panel. It's a more general question, maybe more political science. In the context of climate policies being more and more politicized and debated, so there's less consensus about it. You talked about like some judicial activism, and do you think that the way like to act more for climate through like legal decisions, and especially like with these like quote being supranational kind of debated, I'd say, is it worth it and like more useful? Because like it can like create kind of a backlash about these decisions in the context of like a wave of like, I'll say, decision makers that are not climate accepting, but that are like using as a fuel like the discontent of the reaction to climate change, like to be elected. And how do you think that this reaction will be important in like mitigating the results? Thank you.
Yeah, okay, let's we'll get some, so Veronica, George, Maria, Simon, do you want to maybe speak to the last question?
Yeah.
Okay, and then we have time, so we'll hear those responses and then take a couple online questions and then come back to the room. Veronica.
Super, thank you. So on implementation, yes, the Committee of Ministers meets about 3 times a year, but behind it, there's like this whole machinery of a number of people working on this case and preparing the case and communicating with Switzerland and having these dialogues with specific people within Switzerland. And my feeling when I was there is that they were already preparing for it, and that at the moment they don't know what they should be suggesting, right? And so there is this real need for discussion, I would say, in academia, but also in the political context of saying what would be good measures to redress this, but also for studies, which I'm assuming, have already been done, on what will have what kind of impact, and therefore, why is this one better than another one? So that discussion is ongoing. I would expect, that this case will be upgraded into an important case, and therefore it would get to a meeting, because there are cases that never get to a meeting, but I would expect this one to be debated. When that will be will also depend on Switzerland and its responsiveness, and when it wants, and when the other states want that to be on the schedule, whether that's within a year or before. It is sort of sort of depends on negotiations and lobbying, things like that. I think in terms of the outcome, my feeling is that there's a lot of room here for NGO interventions, right? And the system now allows those kind of interventions and allows for studies also for the applicants to come in and say, this is what we would like doing. And I think those are the processes that I think should really be utilized, because in this context, they're so important. And they would, those kind of interventions would not only make the discussion richer, they would increase the pressure on the politicians when they're sitting around the table and discussing the issue. Because one thing you need to keep in mind is that implementation in the European Court of Human Rights, in the European human rights system is, Chali named it foxes supervising foxes, right? So it's like you are thinking about what you're going to have to do the next time that a case comes against you, right? So you're not going to go for the most onerous of remedies. You're going to go for the minimum possible. So what the Department of Executions is doing and what NGOs can do is really push that minimum up. And I think that was a really key moment at the moment, because it's a first case. It will set the standard for cases later. Thank you. George.
Yeah, so it seems to me that the court did not clarify in the judgment how it understands the prohibition on actio popularis. Sometimes the court seems to understand it as a purely procedural matter of reducing the number of cases. So if everyone is given victim status and we are all affected by the climate change, then that would create practical issues. I think that's not the way of understanding it. I think the idea of the actio popularis is that if you want to stand on your legal rights, you must show some personal, that you have been individually affected. Now, it is the case, I agree with you, that climate change may affect people differently and more vulnerable groups more severely. I think that's the argument the applicants made. So the applicants try to show that in existing principles of the case law, women in Switzerland were more severely affected by the heat waves. And the court didn't have to say anything about climate change. It could have, under existing principles, found the application admissible on the basis that there's sufficient connection between the impact on the rights and the risk of harm that was caused by Switzerland. So I agree with you. I didn't see why the court dismissed this, nor did I see the justification for raising, when it comes to climate change, raising the threshold of admissibility to be a victim status. I did not see that explanation. And of course, these two criteria, intensity of harm and pressing need to address individually, could interpretively be met, I think, in a case like the for women individually, so as it had been met in previous cases. And nor do I see the need for this to be, but I think there's a kind of ambiguity there about the prohibition on actio popularis. Sometimes people understand it as, oh, you have to be affected differently than the rest of the population. So it's comparative. A non-comparative understanding of a prohibition is that you have to be affected. And potentially everybody's affected, so everybody has a claim. Now, the court should have no difficulty with a large number of applications because it had faced this before, delay of proceedings cases under Article 6 in Italy, for example. And the way to deal with that may be pilot judgment or something. So it shouldn't be any problem just because there are thousands of applicants potentially. So I agree with you.
Okay, so the question is really, what do you do when government breaks the law and doesn't care? And I mean, what do you do? It's so I really think law matters, and supporting and maintaining and arguing in favour of our precious legal institutions is absolutely crucial. But our precious legal institutions don't help that much when it really gets dirty. And I think that's true, and I think that's something we've known for a long time, and we're only seeing it now. We've known it in theory, but suddenly we're seeing it. And you've got your legal institutions, and you've got your political freedoms and your political institutions. The legal institutions need to support the political freedoms and the political institutions. The political debate needs to support compliance with the law. That also fails when things get really dirty, and the right to protest is being extraordinarily squeezed in England, and I'm not sure in Scotland actually, but in England certainly it's been horribly squeezed. So what the answer is, I don't know, but we cannot give up on our precious legal and political institutions, and the only thing we can do is keep using them and supporting them.
So there was a question about backlash. Yeah, and you asked, is it worth it? And I think so. In a former life, I worked with Friends of the Earth in their legal team, and you do ask yourself that sometimes: is this worth it? Is it worth the risk? And I think through the process of reading these judgments and reading almost the internal struggle of courts, and I focus on the UK. Australia and New Zealand, a thread running through is this question of integrity. And I think that was quite present and evident to me in the reasoning on Actio Popularis, which is this need to understand how we preserve the integrity of that particular aspect of the convention, and striking the balance in a way that doesn't completely undermine its purpose and its role. And so when we think about is it worth it, and we think about backlash, I mean, if we really do take a step back and we think, well, what is it that courts are doing in this space? I think we've all talked about how this hasn't necessarily been groundbreaking in certain ways. Looking at the detail and looking at the actual work that's happening in these judgments can pay off in asking or in answering that question of whether it's worth it.
Thanks. Virginia Mantovalo, UCL Laws. Thanks very much for a brilliant panel. It was really thought-provoking and fantastic. Thank you all. I just wanted to say something in relation to the sets of more skeptical comments. I was just thinking that litigation can start processes, and we see how this happens here within this room, and it also starts political processes. And Veronica explained to us how it starts processes, legal and political processes in the Council of Europe. So I think we should not underestimate the value of what follows litigation, and particularly such a high-profile case. Even if this case had been lost, this would still start processes and interesting processes. So it raises awareness in areas where that would not, for instance, have been covered by the media. So litigation can start processes, including political processes. And of course, we should not be naive, and we are not naive. It's not the only way in which, we will tackle climate change. There's no, it would be silly to think that, but it does start a process that is very significant. And if it is coupled with other ways, obviously, the right to protest, as Maria said, and the other, political participation more broadly, it is just one of the ways in which we need to use and is used in order to bring broader change and to address these grand challenges.
Thank you very much, and I agree with that. It's in a sense, I think it's just slightly understated the benefit of pumping air into the bicycle tire and creating pressure in the system. But my question, I suppose, is for triggered by something that Maria, you said. You said that climate litigation has an oversized role in this, and this discussion has spoken quite extensively about the case and its merits. But of course, the case has happened, and we have a judgment. And I suppose my question is, what do we take by analogy from this? You can see a theme running through this case, the agenda case, the Client Earth versus Shell case, the current case, Client Earth and Friends of the Earth against Her Majesty's government, all in their own way arguing the case that you can't sign up to a target and then have no policies to implement it. Most state and non-state actors in our society seek to comply rather than wait to have enforcement against them. So what broader lessons can the business community take from the fact that there is this theme which has been given quite a lot of oxygen by this case?
Thank you so much. I'm Naomi Loss. I'm a lecturer here at the Faculty of Laws. So my question really is around access to justice for children and youth. So perhaps a bit of a contentious question, but I'm wondering, should admissibility criteria be different for cases brought by youth and children who have less means, time, and perhaps legal capability to go through domestic remedies? Thinking of both the Portugal case and the Saatchi versus Argentina case brought to the UN Committee on the Rights of the Child. And I wonder if you could comment on the importance of these cases, perhaps in shaping the Swiss judgment that we have, or beyond as well.
Yeah, great question. Thank you. And we'll take one more up here.
Thank you. I'm Tarek. I'm doing PhD on climate migration at SOAS. My question is about another case. So we see that last year, the United Nations Human Rights Commission decided on adaptation. So the Human Rights Committee decided against Australia, identifying that Australia failed to protect the rights of Torres Islands. So the case was limited about adaptation issues. This time we see that ECHR decided on the mitigation issues. Switzerland failed to mitigate some issues regarding. So I think that Paris Agreement has a strong influence upon these decisions. But in the Paris Agreement, there are the third components of climate change, that is loss and damage. So my question is, what do you think that, what's the prospect? How the World Court, ICJ, or the Inter-American Human Rights Court, there are some, or the ITLOS, some decisions are pending on these courts. So what are the prospects that loss and damage issues of climate change might be remedied through climate litigation? What do you think? Thank you.
I'm gonna let folks speak to which question they want to begin with, and maybe we'll start at George and come down here, and then we'll have time to wrap up.
So I couldn't agree more with Virginia about the importance of courts, and I do suffer from the vice that Maria identified of placing too much emphasis on what courts say, but that's because I don't share the assumption that I think Maria attributes, and it's shared by many people, that a case in court is a means to achieve something, that it has an instrumental aim other than vindicating the rights of the litigants. And of course, we want the broader effects. We want the policy to change. We want the legislature to take legislative action and so on. But primarily, when you go to court, you stand on your own rights and say, you know, my rights have been violated, and I want this to be declared by the court. And you want usually a remedy for that. So we shouldn't assume that a case can change, have large case implications for the rest of the world. Typically it doesn't. Typically it's just individualized judgment. And I think that's the issue that the standing requirement brings to the forefront. So we shouldn't instrumentalize courts and think of them as just another way to get things done. We should rather think of courts as vindicating legal rights. And the question, of course, is what those legal rights are. But I think lawyers are well placed to do that. Now, having said that, cases do trigger change. And in particular, in the context of this ECHR, we have to remember all those cases where they were followed by large-scale reforms on the part of the respondent state. In my own home state in Greece, the landmark judgment finding a violation of freedom of religion to protect large religious groups in Greece who have been persecuted by the Greek state. It was a major reform and had a massive impact in the lives of those people. So we shouldn't forget that. Now, on the point of youth and children, I think this ties in with the point I tried to make about the importance of thinking about the rights of people while the risk hasn't yet materialized on their lives. And when this materializes, then it will be too late because the violation will already happen then, and it won't be able to prevent the violation at the future time. And you know, younger children, younger individuals, and future generations, I think, are pivotal for how we should think about cases of climate change. That's not to say, so in response to Maria's point, that we should have like a competition of whose interests matter the most, like the elderly women in Switzerland suffering from heat wave, or younger children as they will suffer in 20, 30 years, 40 years, or people living in 100 years. It's not a competition of whose interests matter the most if the underlying principle of the court can be universalized. So if it is with certainty that some rights will be violated under the convention, and if there's no possible way to vindicate those rights, then we should recognize a legal remedy. Now, I understand the issues around funding and who brings the case to court and so on, but this is like seeing the glass half empty. I think if you want to see it half full, you're just going to say, well, funding should be better regulated, and we shouldn't allow the hegemonic actors to bring cases that only benefit some people. And that's for me is only an argument for expanding litigation as opposed to be critical about it.
Sorry. I have a comment in response to what George has said. So I think that's fascinating, and it speaks to the fact that we are kind of crossing over different fields, because having only, I consider myself an environmental lawyer, but my focus has been climate litigation in my work. And actually what you have outlined, which is, instrumentalizing courts, that is the dominant narrative about what courts do. And I think that's quite different to the perspective that you just outlined, which is an idea about rights and vindication of rights in a court. That discussion is largely missing in the discourse about courts in particular. And I think, to me, that I can see the kind of the crossover from what Maria has set out and what Lisa has talked about. And actually, it's really fascinating to see how they perhaps don't speak to each other as much as they should be. But yeah.
I don't quite know where to start. I mean, Solon addressed George's comment much more politely than I could. That's very good. So I'm not a skeptic of litigation. I don't think litigation in itself is a bad thing, but this is a campaign. It isn't about vindicating individual rights. It is a campaign, and as a campaign, it has to do something in the world. And my question, and it is just a question, is whether the extraordinary levels of attention being paid for good reasons and not so good reasons to cases distract us from other ways of doing things in the world. And things do need to be done. It's not a small problem. So I'm not a skeptic about litigation at all. And I am looking at it really from the perspective of civil society. In civil society, there are a lot of people giving their lives and, gold to making this happen. Virginia's point about process, absolutely, I completely agree with you. But who is there? That's my question. Who is in the process? We rely on environmental groups to put a non-dominant perspective into these processes. And I'm not convinced that anyone is going to help the environmental groups to put that perspective in the processes. So that's my worry, that they're enabled to be present at one point, but then they're not enabled to be present at the rest of it. So that's my concern, not really with anything that you said. In terms of themes, I was really interested that you cited a load of English cases, because the English cases are not promising as, courts as ways to sort of progress climate action, I wouldn't say. So I wouldn't take any promising themes from the English cases particularly. And I think the ECHR decision is a counterpoint, in a sense, to what we're seeing happening in the English cases. I'll leave it to that. Thank you.
Still got a decision pending.
Well, we've been waiting for Finch for, I've been refreshing future decisions page for about a year and a half.
Create an idea, which is a governance idea, and actually people in charge, whether it's of governments, of countries, or businesses. If you set, and there's a lot of the greenwashing discourse at the moment goes through this as well. If you set a target, you have to deliver on it.
And it's
a dereliction of duty, whatever the nature of that duty is, however you can enforce the failure to perform a duty. There is a duty that needs to be implemented through policy and measures. And so I think it's potentially influential
And
outside of litigation, in the world where most actors seek to comply with the expectations of social license to operate or political discourse. So I see it not as useful for cases, but possibly influential for conduct and behaviour.
So I think it's really important to show powerful actors that they will be held to account for what they say. Courts aren't the only way to do that.
I agree.
Yeah.
Super. So I'd like to address, I think, two sort of points. One is the access to justice question and the admissibility criteria. And I think in reality, and I feel like I know a lot about ECHR case law, I know nothing about who makes it as a victim, who it's able to turn to, so who can make a claim, who gets through the 5 stages of admissibility, right? And who falls at which criteria, and then who actually wins. So like my next project is trying to understand who actually makes it through to these international human rights bodies, and who enables them, right? So who are the facilitators? Is it the lawyers? Is it the NGOs? Is it the funding? Because at the moment, like I couldn't, but this is a question I can't answer. And I'm sure, there's very little literature on this. The other thing I wanted to say, yes, this is a campaign, but I think we need to sort of super be aware of that it's very difficult to talk about universalism here, right? So each body that people or NGOs turn to has a different jurisdiction, it has a different competence, it has a different focus, and it's different, like it's embedded in its own environment. So for example, at the moment, the Inter-American Human Rights Court is listening to the advisory case, right? And Inter-American Court of Human Rights is really progressive in terms of remedies that it always awards. And so we expect those judgments to be really, really rich and really, really strong in terms of what they require of states. But the Inter-American Court of Human Rights is not really concerned with compliance. Their compliance rates are about 20%. So it's a totally different context from the European Court of Human Rights, where compliance is a concern for a judge that is rendering the decision. And therefore the decision is going to be more modest. So even if the campaign is universal, even if the push and the pressure is, what we get out of the process is different because of the different institutions. But for me, I think what I'm working on, like what I'd like to see change is that we rethink the end, that the judgment isn't the end, that the judgment is just a piece of a puzzle that keeps on happening, and that's how we need to think about any human rights litigation, including climate change.
Yeah, fantastic. I've managed to give myself the last word before we all step out for a quick drink, so I'll be very brief. And I think the questions on loss and damage are a really interesting one, and we're only just beginning to see that in that climate litigation sphere. So I think there's a lot to watch out for there, but I expect those cases will look very different in some ways from the climate mitigation ones. So as those judgments roll in, let's reconvene and think about how that plays out. I wanted to come back to Virginia's point and George's, about other processes and glass half full versus glass half empty. And of course, I would say this, and it's my job to say this on this particular panel, but for me, that's an empirical question. And we need to be careful about assumptions, because processes, positive processes of awareness raising and political mobilization and governments taking this more seriously. The flip side of that is, maybe those Portuguese young people feel really disempowered right now from having taken part in that process. Maybe if they had been in the streets instead, a different kind of result would have been achieved. When we think about these court judgments, what are they doing in terms of both the way, for example, net zero scrutineers are understanding what's happening and how politics are being made, and the way that reflects back on this court. So all of these judgments always enter into this political space again. And so it's just the kind of question about what is it that we're focusing on, what's the outcome that we're looking at, what's the methodological approach we're taking to really make that assessment at the end of the day, that it doesn't end with law. But that does end this panel. I think it has been such an amazing hour and a half spent. We've heard about the case, we've heard about kind of the details of the case, the dissent, the kind of broader context within this, both in terms of the international relations of the court and, domestic courts, and thinking a little bit more about those kind of social movement dynamics that have been brought up and the political consequences of this. So please join me in thanking our panel.